Hi, Wes Scott from Lifeback Law Firm. Today we're going to talk about a common issue in bankruptcies, and that is bank refuses to retrieve their vehicle, their collateral. In Minneapolis, Minnesota, Chapter 7 bankruptcy. Why? So we have this situation where, people file Chapter 7 bankruptcy. Typically, they want to keep their cars, so they continue to make payments on them. But of course, what happens? Well, the car eventually poops out. The car eventually needs more repairs than it's worth. And so what do? Well, you stop making payments on it because you're not liable on the debt anymore. And then, you want it out of your driveway. You want it out of your apartment parking lot, right? Or the landlord does because it's an eyesore and it's getting in the way of their snow plows, etc., etc. You call the firm and you say, hey, I've reached out to this lender. They won't come and get their junk. What do I do? Well, they're not coming to get their junk because you think it's junk. And if you think it's junk, they don't want it back. And so what do? Well, I have found the trick here is to send the lender a certified letter, right? Send the lender a certified letter stating that if they don't come and pick their collateral up, and identify the collateral, within 14 days of the date of this letter, or make arrangements to come and pick up the collateral within 14 days of the date of this letter, that you're going to have the vehicle crushed. Now, I say crushed because you can't sell it. You can't sell the vehicle unless you get a lien release, or you're going to have another problem. You can't part it out because there's a lien against it. And companies can't part vehicles out and sell those parts when there's a lien against it. That's a crime. So the only thing that can be done with this vehicle is it can be crushed when the time is right. When you are ready to get your life back, reach out to the most kind and helpful bankruptcy law firm in Minnesota. Right here at Lifeback Law Firm, you're going to be so thankful you did.